So the question is, what are family law court hearings and trials? Come with me and I'll give you an explanation. Family law hearings and trials are hearings that are held inside the courtroom before the judge, where the judge makes decisions about law and facts. Typically, there are hearings at the beginning of the case, sometimes towards the middle of the case, where you want to make a fast determination about custody and visitation, about child and spousal support, about the division of assets, about the use of assets and the payment of certain debts. In family law court, most things are done by way of declaration at these hearings. You and your witnesses present declarations under penalty of perjury. However, if you and your attorney follow the rules the correct way, you can also put on witnesses at these request for order hearings. At the time of trial, unless both sides agree, declarations are usually not permitted because they're hearsay. You have to have the real witness at the time of trial. I want to tell you a short story about a trial in a family law case. We had come to a date where the judge, I got the feeling, wanted us to settle this case, because if we didn't, there was going to be a long, protracted family law hearing and trial about child custody and visitation. We didn't come to an agreement, and my client, who was the father, was adamant that he wanted a certain amount of visitation with the child. The mother, on the hand, was adamant that she wanted the father to have as least as possible visitation and custody of the child. I speculate that the reason why the mother took that position, because the more custody she has, the more child support and spousal support she gets from the father. At the beginning of the trial, I was always under the impression that the judge was leaning towards the mother and against the father. It wasn't anything that the judge said or did, it was just a feeling that I had about some comments or questions that the judge was asking. We went through the trial. The trial took about 3 days. And at the end of the trial, the judge ruled in favor of my client, giving him 50-50 custody. The reason why the judge did that was because certain things came up during the trial that surprised not only me, but the judge and the mother's attorney. Here was the one thing that I think helped us the most. I don't think the mother's attorney ever thought that this case was going to go to trial. I think that attorney thought it was going to settle. The attorney, I don't think, prepared the mother for testifying. And by preparing, I don't mean telling the mother what to say, but showing the mother how to testify in the most convincing way, how to act, what kind of attitude to have. When the mother got on the stand, she probably was one of the worst witnesses I had ever seen. She was belligerent. She refused to answer questions. She yelled. She laughed. All of these things are things that you don't want to do when you're testifying at trial or at a request for order hearing. So by the mother acting that way and coming across basically not credible, the judge made a decision and ruled in our favor and gave us 50-50 custody. Had I known the mother was going to do this, I would have probably asked for full custody, although I don't think my client wanted full custody because he was a working guy and he didn't want to have, he wasn't able to take care of a child on a 100% basis. So when you're going to trial or you're going to an RFO hearing, make sure that you meet or at least talk to your attorney about the possibilities of you testifying and how you should testify. You should always tell the truth. Don't get me wrong. I'm not suggesting you make up things. I'm suggesting that you can tell the truth, but you can tell it in a certain way to be more credible. At my website, I have a DVD that's available on the web, How to Testify in Court. It'll just give you some certain tips that you probably would have known if you thought about it, but when you see it in the video, you'll get a better feeling on how to come across. Here's one of the tips. When you're asked a question by one of the attorneys or the judge, let the person finish the question, take a breath, let your mind and your subconscious catch up with you, and then answer the question. You'll come across better, you'll come across more credible, in my opinion. The next email you're going to receive is going to be a video talking about domestic violence restraining orders, also known as the DVTRO.
For your free consultation, call the law offices of Vincent W.Davis and Associates today. 1-888-888-6582. That's 1-888-888-6582. Thank you for watching.